Hello, welcome to today's webinar on complaints. Thanks for joining us. I can see that a number of people are actually still joining us at the moment. For those that don't know me, my name is Naomi. I am the ATAS Compliance Manager, which is the designated role of our ATAS Charter and Code, and my title is the Head of Compliance and Operations. So today we're going to be talking about complaints. It is a difficult area of business and it is something that we deal with here as part of the ATAS complaint process, and it is really a benefit to your businesses as being an ATAS accredited agent, having the process that we have to assist you and to assist your customers. So I'll talk a little bit about why complaints are important, then we'll look at our process, which is in the charter, and then as part of the code, look at that escalation process that all ATAS accredited agents must abide by. Then we'll talk a little bit about the appeal committee, where complaints can be appealed above our stage 2 process. Then we'll talk about some best practice. Then I'll touch on apologies and UCC, which is unreasonable complainant conduct. And then I'll look at a couple of examples of the different types of complaints and where they've gone with us here at ATAS. Okay, so ATAS does have a strong focus on consumer complaint handling and dispute resolution. And if you have read the charter and the code, which all businesses should be familiar with, you'll be aware that it is embedded very deeply within those documents. So complaints, they can be quite stressful to all involved. As far as an organisation is concerned, it can result in, a loss of focus, unnecessary time and resources, can affect your reputation, staff turnover. There really can be a lot of impacts from them. On a staff level, it can create stress and anxiety and frustration, and it can affect productivity. And also for the complainants, and what we do see here, especially with complaints that get escalated to us, is, they start to get a bit of a loss of perspective, so much so that sometimes they can get more upset about the way that their complaint was handled than what the original issue was. So it can be very stressful on everybody, but again, having this process is a real benefit to your business because you can use that to take that stress and that heat away once you have dealt with it. And that sort of highlights good complaint management. If you look at it and handle complaints great, it can actually really work to improve the products and services that you offer. And it can really build consumer loyalty. It builds trust, and your customers will share that experience and they'll come back to you, which is, really important today. And in that respect, it can improve your bottom line. If you don't handle complaints well, it can be quite bad for the business. It can end up that you would end up in court or tribunal. That in itself takes time and expense, but also just the time and expense to your staff as well if the complaint goes on and on and on. And that, of course, can damage your business and your brand and your reputation. So it is really important to really take it seriously, which is why ATAS definitely embedded in. And so it is really part of the charter and the code. The code is actually a part of the charter. So we'll touch on these two documents now, which is available, on our websites. And And what I will touch on is mandatory for ATAS accreditation. So it is something that we check for new applicants, it's something that we check at renewals, and where we see systemic issues with non-compliance, it can result in cancelled accreditations. So what does the Charter say? The Charter says in section 2.5 that the applicant must be committed to efficient and effective resolution. And they must be committed to this by way of having a complaints handling policy. Now, every single ATAS member has submitted to AFTA a copy of a complaint handling policy when they became an ATAS member. So one exists in every single business. So it's really important, though, that this is communicated to everybody what this process is. Now, if you're not sure, we do have a draft template that is available on the AFTA website that complies. And this is what we give to new applicants that are looking to join so that they can use that template. So as part, with regard to this policy that you all must have in your businesses, what the Charter says is that when a dispute arises, participants must make it clear about this internal process. And then if a customer is not happy with the outcome that you do propose to them, you must make it known about the external process, which is this process. So basically, it needs to be accessible and transparent regarding your process internally of how you deal with complaints. And I will touch on it a little bit more. It actually comes up quite a lot. So in the Code of Conduct, so that was in the Charter, so that's the eligibility criteria we just talked about to actually become ATAS. The Code of Conduct is our consumer-facing document. So that's your document that you're saying to all of your customers, this is the Code of Conduct that we abide by, and this is our service commitment to you, and by being an ATAS member, this is what we're saying we will abide by. So within the code, it starts off strong about complaints. ATAS has a strong focus on consumer complaint handling and dispute resolution. As a result, we are actively committed to helping you resolve any complaint or concern that you may have about the way in which we provide our services. What the code does say is that this internal policy that you have for complaint handling must be easy and free to access. And it also must comply with the Australian standards. Now, the template that I talked about before, that is built to comply with this standard, and the rules that we have in the code are all built to this standard. I can't share that standard with you, it is copyrighted, but I will send some links at the end that standard is actually built very heavily on the New South Wales Ombudsman complaint handling processes, and there's some amazing resources in that if you want to delve more into what you can do. So I will send that at the end. But the point here is it does need to be easy and free to access. And because this is in the code, we actually end up getting complaints that come to us and say, well, I couldn't find their complaint handling process, couldn't find what their policy was, they've breached the code, they shouldn't be ATAS. We end up getting a lot of that, which is nothing to do with what the original complaint was, but it's very important that all your staff, and especially the frontline staff and the complaint handlers, understand that this does need to be able to be accessible and communicated to complainants. So the code then goes through a three-stage process. And starting on the bottom of the pyramid, it's your process, what we've just been talking about with the agent, an internal dispute resolution. And the majority of complaints are dealt with at this stage, and most agents do an amazing job. However, then there goes to stage 2. If they are not happy with your outcome, they need to be communicated that they can raise the complaint to ATAS. Your amazing ATAS agent, we're committed to this code, we have this process. It's a great selling point for your business about what being accredited means. And then that I make a decision as the ATAS compliance manager regarding stage 2, and that decision can also be appealed to stage 3, which is our ATAS Complaint Appeal Committee. And I'll talk about those all individually now. So with regard to stage 1, that's your internal dispute resolution. You need to communicate to complainants that you will resolve within 21 days a complaint that's raised. Now, if it's going to be longer, you're looking into it, the supplier's overseas something, that's fine. You just need to communicate to the complainants that it's going to take longer. So the key timeframes that the code sets out for you is that you must acknowledge within 5 days of receiving a complaint, and that you will attempt to investigate and inform of the outcome within 21 days. So that's 2 of the keys. We do get complaints sometimes that, oh, nobody's acknowledged my complaint. They've breached the code. They shouldn't be ATAS. So most people do a brilliant job of it, but it's just one of those things to build into your processes who's responsible and who's going to acknowledge. Then stage 2, that's when they can escalate a complaint to ATAS. They're not happy with your outcome, and I'll talk a little bit more about what you should be doing as part of handling your complaint after I go through the 3 stages. And the way that they can lodge it, and this is written in the code, is that they can lodge it online via our atas.com.au, which is the consumer-facing website. We also receive complaints by mail, by phone, but we do recommend using the online form because it is built to capture the information. So this is our ATAS website, and you'll see up in the corner there it says lodge a complaint, and that's where a consumer can go to lodge a complaint, upload documents, and basically submit it to us for consideration. So as ATAS awareness has grown year on year with all of the marketing that we do, the more that agents are embedding this process into their system, which we are seeing a really wonderful effort by agents using this process and embedding ATAS into their narrative in their benefits of being accredited to consumers. We have seen complaints raised, but more increase over time, but we see that as a natural thing and actually a good thing that more consumers are aware of this process. So of last year, the 669 complaints that we received, 192 of them we did refer back to the agent. We said, okay, we see that you've lodged a complaint with us, but you haven't gone to the agent and lodged a proper complaint with them. So sometimes they might have, talked to their consultant and not been happy with the outcome, but they actually haven't properly gone through the process. So, there's probably some scope in that area that businesses can improve on ensuring they're going through a proper complaint process with a formal written outcome before it comes to us. But we will always, in every circumstance, give you, the agent, the opportunity to resolve a complaint first. We would prefer that they're all resolved at that stage, but we understand that's not always possible. So when it comes to us, then we have a 45 days allocated by the code to investigate a complaint. And usually the first thing we'll do when we get a complaint is come straight to you, the agent, for your version of events and any documentation that you wish to submit to us. And from that, we'll have a look at, you know, if we think that there may have been a breach of the code, and make a determination. So what the code says is that we can do one of 5 things. We can seek to resolve the matter by mutual agreement, and this is always our preferred option. It's a win-win situation where both parties can come to a resolution and we can close the complaint. Everybody understands that there's closure. So this is the best scenario, and this is what we would try to do in every instance. One of the other decisions that I can make is that I can decide that they've already taken action or proposed to take action that would sufficiently resolve the complaint. C is that we can require you to take action. So I'll give you some examples of action that I've required people to take. It might be that they update something on their website that wasn't working properly. It might be terms and conditions weren't clear. It might be, you know, improving that staff member's knowledge of ATAS and complaint handling. D is find that we have not breached your obligation. So this is basically when, you know, the complaints come through, but we decide that we don't believe that there's been a breach of the code. And E is that we think they've breached the code and we can refer it to the committee for an independent investigation. So this is our 2018 data. So last year, out of the 129 that we accepted for investigation, 54 were resolved by mutual resolution. As I said, that's the preferred option. In 25, we decided sufficient action was taken, and 12 we required to take action, and in 37 there was no breach. Now, where there is no breach, or we've decided that there is sufficient action taken, the complainant has the right to appeal that matter to the ACAC, and they have 90 days to review the complaint and make a determination. So the ACAC, it stands for ATAS Complaint Appeal Committee, and basically it is you know, where they go to complain about how we've managed their complaint, that they disagree with the outcome that we have made here at ATAS, and they review all the material and make a determination. It's made up of 2 consumer representatives, and it's made up of 2 travel industry representatives, and it has an independent chairman. A lot of them are lawyers or ex-lawyers. So if once we issue our outcome, a complainant's then got 14 days to appeal that to that committee in writing. So last year there was 10 appeals against decisions of mine. In 6 of those, they dismissed the appeal, which means they essentially agreed with me that there was no breach. However, in 3, they did make orders for rectification, which it did include repaying some money, and in 1 there was also an improvement notice, which I believe was changing the terms and conditions that were communicated to consumers. I think that this actually demonstrates that the process actually does work, because if we were, say, getting, you know, all of those appealed and all in all instances it was a different decision than mine, then you'd think that there was something wrong with the process. But this actually demonstrates that the process is working. And I'll talk about a couple of those at the end, but we do list on the AFTA website under ATAS a summary of all of the outcomes of the appeals that are heard. They're de-identified for privacy, but it does list what the issue is, whether there was a breach, and what the sanction was. In total, last year, through the process here at ATAS, $133,000 was returned to consumers through negotiation, or whether it was by rectification order of the committee, which was a really big increase on the previous year. Okay, so did anybody have any questions about the process of the code charter? If so, please, by all means, put a question in for me. I'll be happy to answer it, or I can do so at the end. Where did you say we could find examples of the cases? So the cases that the committee here are listed on the AFTA website. And then if you go to the tab ATAS, and there is a option, sorry, I'm just thinking, option of ACAC. And under that page, it says, it lists it all there in a box. If not, I can send it to you afterwards. It does say, I've got another question, is it mandatory to have your terms and conditions on your website, or is it sufficient to hand them to a client in hard doc form? Look, it's best practice, and we usually see it on a website, but it's actually more important that you are handing them to a client in hard form. And I will touch on this in a little bit, actually, so I might come back to that in a second, because I have a few things to add regarding terms and conditions, because it does come up a lot, so I will come back to that. Okay, so going through, so that's our process. Now what I'm going to do is just touch on the key things that whoever's handling within your organisation, some 10 key points I'm going to touch on. So the first is welcome complaints. Be open to complaints. They can be a real benefit to your business in understanding your weak points or where you can improve. So you need to develop a culture that looks at complaints favorably and as an opportunity to learn. And develop a culture that doesn't make your staff feel like they're going to get into trouble or that they can't admit errors. You really need to foster that it's okay. It's a good thing to raise it and correct it. So 2, a clear process. Design a clear process for managing your complaints received, including who within your organisation is going to be responsible for dealing with complaints. Make sure all staff are aware of this complaint management system and the steps that they need to take when a complaint's received. Once you build that in and have that clear process, none will ever slip through the cracks, and everyone's aware. And empower your staff, empower your frontline staff so that they understand what they can resolve at that level and when it needs to be escalated. Acknowledge receipt. So we talked about this in the code. In the code specifies that you specifically have got 5 days to acknowledge receipt of a complaint. Assess the complaint. So this is where you actually really look at and assess the issues of a complaint. Decide who is going to deal with it. If it can be resolved immediately, great. Resolve it immediately. If it can't, decide what action is going to be needed, whether it's going to involve investigation. You're going to have to talk to consultants, suppliers. It could be a wide range of things. Also consider when you assess vulnerability of the complainant. For example, they may not be fluent in English. They may have an intellectual or physical disability. So also make an assessment of the actual complainant and whether you're going to need to apply more resources to that. And we also sort of flag complaints if we know that it could be a possible one that would be escalated, that is going to require more attention. So, keep all those things in consideration with how you're going to treat the complaint. Or, it might mean that it needs to be escalated earlier if it's a problem. And we'll talk about that a bit later too. Manage expectations. So this is a really important thing, and it's something that we really focus on too when we handle complaints. You need to provide the person who made the complaint with information about what you intend to do about the complaint and evaluate their response. If you feel that it's likely the described action will satisfy them, then take that action. But if further review is necessary, give the complainant a clear time frame for when to expect a response. Even the most difficult customers, if you keep them in the loop, as to we are still looking at this, we hope to come back to you next week, we have 45 days in total, just keeping them up to date, they really appreciate it and become much, much more easier to deal with. It's when you don't and you just sort of leave it out there in the wilderness that then if they feel they've got to keep chasing you up, they're going to start getting more angry, they're going to start getting more difficult to work with. So it's a very easy thing to do to just keep going. We're still looking at this, just to let you know, they appreciate it so much. Honestly, it's a challenge for us as well, but it really is an important part of complaint management. And then finally, inform the complainant about the outcome. We recommend you do this in writing and that you list the following things at least. That what action that your business has taken, the outcome of the complaint, reasons for the action taken, what you are offering, whether you are offering any compensation or apology, and information about further avenues. So if they're not happy, you can go to ATAS. And look, some businesses do a brilliant job of this. It is really tight what they write back. It's very clear. And that's what complainants are looking for, especially about what action you're taking and the reasons. Why did this happen? So if you're very clear in being able to do that, this can usually resolve a complaint. So, but it is important, and I think some agents can probably improve on the actual format that this goes in, because some people, just a short little email isn't really giving the complainant the closure that they need. So this brings me to key point 8, which is record keeping. You should, as a business, keep a record of the complaints you receive and the decisions and outcome of them. And this data can prove to be really helpful for your business. You should regularly review it, look for any trends or obvious issues that you could address to stop future complaints. And improve your services. You could also look at introducing a survey on your complaints process, depending on obviously how many you do get and the size of your organisation. We do it here. It can get quite skewed, the data. Obviously, we get amazing survey results for the people that we get a resolution for, but where we say no breach, obviously they don't have very nice things to say about us. So the data can be skewed, but it can be, again, just another helpful tool in understanding your process. And key point 10. So complaints is a hard thing to deal with, but it is so important that you apply objectivity. It can be really easy to be defensive when you do get a complaint. So this is where you really need to try to apply these traits. Openness, impartiality, confidentiality, accessibility, completeness. It is difficult, and some days I have to say, to my staff even, let's practice our empathy today, okay? It is important to apply, but listening and being objective, it goes a long way to just what the complainant actually wants. But it is a challenge, and trust me, we get it a lot, and we do get a lot of extremely aggressive complainants sometimes. A little quote there. It is so important, especially in today's day and age, with the internet and communication, that consumers are in a position to really publicise their complaints. So it's so important to be able to communicate. Okay, just having a look at a couple of questions that have come in. And a lot of them are about terms and conditions, so I might just come to that when I talk about that in a second. So complaints, this is about like the ATAS office, really. We don't really get to hear all your wonderful, amazing, good news stories. We just get the complaints. But we understand that there is a lot of good news stories. Okay, so I'm just going to very quickly, go through a recap of the code obligations. Now I do want to focus on actual complaints and complaint handling. So if you do want to understand more about the code, and in particular consumer law, I did a 2-part series on consumer law last year, and those 2 webinars are available on the AFTA website. So I don't want to actually focus on that. I will come back and answer the questions at the end, but just know that there is 2 one-hour consumer law webinars, and if you ever have any questions, you can always contact me yourself directly. So very quickly, the obligations in the code. The aim of the code is to set a minimum standard of behaviour, and it's to hold all ATAS agents to the same standard of behaviour. It's there to establish an independent process for assisting consumers and agents to resolve complaints, and it's about building professionalism. So this is in the code. This is what consumers will see when they're looking at you and what you should be abiding by. Now, the main obligation is the service quality promise. And what this says is in providing our services, we will advise you of relevant options and alternatives, be receptive to suggestions and feedback. Importantly, in bold here, disclose all relevant information in a plain and easy to understand form. This comes up a lot, and it does sort of come up tied with terms and conditions. Communicate with you in a timely manner. That comes up as well from time to time, people not responding to emails. Monitor developments externally. The one in green is important. Ensure products and services are fit for any disclosed purpose. Now, this is a consumer guarantee, so if you want to know more about that, again, in that webinar. So that really is about when somebody asks specifically for something. In green is another consumer guarantee, which is that you'll act with due care and skill, not engage in misleading or deceptive nature, acts or omissions. Another one from the consumer law. Act fairly and reasonably. Treat with respect, consideration, and then there's a general comply with the Australian consumer law. Now, the other one that comes up all the time in our complaints is that terms and conditions be provided at the time of or before you enter into a sale with us. So, as that question was asking me before, it is actually better that you be handing them in a hard doc form. Now, the best agents that I see, the best practice is they actually get every single terms and conditions signed by their customers, signed and dated, that they acknowledge and have read. The actual best practice I've seen is this copy gets highlighted with the main things, like the main, non-refundable, these are the details, this is the name of your passport, and they tick yes or write yes to those really important terms and conditions. So this can't be, honestly, overestimated. It really is one of the things that just come up. And we all know that people, if you're going to tick a box, aren't going to read it. So it is important to try to highlight the really important terms and conditions, especially refundability, cancellation fees, and if something is non-refundable. I'm going to just go through a few of these other questions here. Can we say that PACs are totally responsible to get their own visa and check passport validity, not us? You can say that, okay? So that's general advice. But if then they ask you a question and you respond, that will override any term and condition that you have that waives all your liability, okay? So you better, if that's going to be your position, be very clear and stick to that position. Where we're seeing issues and problems is where people do have in their terms and conditions, yeah, it is your responsibility, visa and passport, but then they've asked a question or they said, no, you don't need to worry about a transit visa for that country. Oh, guess what? They did, because they were on a different type of passport. So I guess the key is being very clear about it and being very clear up front when they book a ticket. Don't leave it just in your terms and conditions. Make it part of the conversation. Say, because of the complexities of 190 whatever countries and 190 different types of passports, we can't give you advice, but here is a company that we use. They will be able to do that service for you or via you, however you do it. Everyone does it a little bit different. But I guess it's just being very careful about when you go from that general advice and then you make it specific advice. That specific advice is going to override it. I hope that sort of answers that a little bit. If conditions are on a website, referred on all invoices and receipts, and also verbally, can passengers still say, I did not get to read them? Well, this is the question, right? And it goes back to what I was saying before about best practice, about people ticking and acknowledging the main terms and signing, because then it not only shows to the consumer, hey, you are agreeing to this now, it protects you as well. Even though you can't contract out of your consumer guarantees, right? No matter what, you still have to apply due care and skill. The fact that you've ticked it and got them to sign it is part of demonstrating that you have exercised due care and skill in communicating those terms and conditions. But look, it is something that comes up. So, the way you can best embed it into your business to make it clear, the better. Okay, I'm going to, I've got loads of complaints, hang on. Not complaints, questions. See, I've got complaints on my mind. Okay, all right, I'll go back and we'll continue on for a little bit, and at the end, if you've got more questions, put them through, we'll go through some. In the code, it says, we will promote this code and we will make it available on request, and we will advise that the code is available to AFTA. Best practice, again, would be put your code on your website yourself. Okay, so moving on, I'm going to talk a little bit about apologies. And the reason I want to do this is because I think a lot of the complaints we get could easily have been resolved just with an apology, and could have saved a lot of time and effort on everyone's behalf. So we do hear this line a lot. I believe I'm at least owed an apology. So a full apology can be really beneficial because it really restores that dignity and reputation, and complainants really feel that they've got, you know, some justice, and that they were right. Not that they are always right, but it does just give them that peace of mind. And apologies are really actually very powerful in helping to resolve a complaint. So the Ombudsman lists, in most states, lists these 6 R's that you need to consider when thinking about an apology. 1 is recognition, 2, responsibility, which is admission of the responsibility or fault. And we really see that this is what drives a lot of complainants. They want somebody to accept something went wrong. An expression of regret or sympathy. The reasons why it happened. Again, this comes up all the time. I just want to know why and how did this happen. Redress, so, you know, what is going to be done to fix it? Again, a lot of complainants just say to us, I just want to make sure this doesn't happen to anybody else. Whether that's true or not, or they actually really just want money back. Genuinely, many complainants really just want to make sure it doesn't happen. And I think you really need to pay attention to those ones because, you know, you really want to address that if there is an issue in your business, to make sure it doesn't happen again. And release. So in some cases, they're sort of, you know, are looking for forgiveness. Things to avoid in apologies. Again, brought this up because we also see a lot of times when an agent does apologise, but all that's done is made the complainant even more angry. So I'm just going to go through this quite quickly because I've just got a few more things to go through. One of these is inaccurate apologies and misguided. And down the bottom there, I've got generalised. And this is where it's just said, I'm sorry for what occurred and mistakes were made. They really want actual details about what you're apologising for. Other ones include avoidance apologies. I'm sorry you took offence at what I said. Not addressing the actual issue. I have honestly listened to people just rant and rave about how angry they are about basically half-assed apologies that they just don't feel genuine. Again, conditional. If you're offended by what I said, then I'm sorry. Again, it's not really addressing the subject either. And partial apologies. So I'll talk a little bit now about partial apologies because there is some legal liability questions that come up about apologies. So in 2002, New South Wales and ACT, and Queensland's later joined, they did introduce legislation to try to avoid legal situations by making apologies not subject to civil liability. Because some, people don't want to make an apology because they think that it's admitting their guilt. So in New South Wales, ACT and Queensland, the legislation actually says that whether or not an apology admits or implies an admission of fault in connection with the matter, then it cannot be provided as evidence in connection with civil liability in court. So that is only in those states. So in SA it applies as well, but it excludes defamation, so it could be used in defamation. But in WA and Vic, it does not. Apology means that only where it does not contain acknowledgement of fault. So I guess definitely in those states, you would probably need to be a bit more careful. But I think for the most complaints on the small end, where it's just a service issue and we're not talking about a lot of damages, then an apology really has its place. If obviously, there is liability and damages that are serious, then you would really need to get legal advice regarding that. But as I said in the beginning, the reason I want to discuss it is apologies really go a long way to helping resolve very early on, before it even gets escalated in your own businesses. It can really go a long way to fixing the problem. Okay, so what I've got about 10 minutes left. So I'm not going to deal a lot on unreasonable complainant conduct. Now, this is really where you've got behaviour that is a risk to your business or to your staff, and it really is unreasonable, persistent demand, lack of cooperation and arguments. And you probably do know the type of person I'm talking about. Some people are, well, they have their own classification, and this is what it is. It's called UCC. Now, if you really want, and it is an issue for your business, then what I'd recommend is Googling New South Wales or Commonwealth Ombudsman and unreasonable complainant conduct. They have really detailed policies and procedures for this. We've had a few, and basically, it involves a lot of yelling, screaming, abuse. It involves, submissions of, 60, 70 pages every time we asked a question of the complainant. It was just really, unreasonable. But my advice to you would be, don't call it that. Don't ever call them frivolous. Don't ever call them vexatious. Use this process. You have the luxury of that. Well, you can go through your process. Well, the next process is that you can escalate the complaint to ATAS. So use that, make the most of it, and that is the benefit to your business of this process. So some of those can be very hard. I have to tell myself this: remain cool, calm, and collected. Really listen. Just listen. Let them vent. Let them let it out. Let all that steam off, and let them go until they stop. And then only start the conversation. And you'll find by that stage they're so exhausted. Usually, you'll be able to talk to them. For your businesses, if you have that, to protect your frontline staff, it can be extremely stressful to deal with. Make sure that, they are aware of the process, that those sort of things need to be escalated quickly internally to more senior management, because it's not fair on them. And that type of complainant will always want to talk to the top anyway. Don't dismiss them. As I said, don't call it frivolous and vexatious, and use the ATAS process. Okay, so now I'm just going to go through a few recent complaints that we have dealt with and the different types of ones, and then I'll come back to these questions, and there's a few of them there, so we'll come back soon. Okay. So here's an example of a mutual resolution. So these are what we're trying to get. So this consumer had requested full service on an aeroplane, in particular that they wanted wine. So they booked the airline on the agent's recommendation, but found out just prior to leaving it was not full service and they could only have beer on board. Now, the agent was doing a good job in this regard because they were trying to negotiate something. They were offering them something. However, what they had offered was that the complainant take little bottles of wine on board from duty-free. So this was when it came to us. We read this offer, and obviously the complainant, not happy. Very quickly, I did a bit of investigation. We looked at the website of the airline, and we found out that they were not permitted to drink duty-free on board, and that the small bottles of wine were actually larger than the liquid size allowed by customs. Now, this didn't take very long for us to look into. So I guess what I'm trying to point out is that if you're going to make an offer, it does truly need to be reasonable. So we went back to the agent on this one. They acknowledged that, okay, yep, their solution and offer was not. The complainant was demanding, I can't remember actually offhand, I think it was $600. We negotiated, I think it was round to $400 each. They both accepted that and it was mutually resolved. So both parties knew it was closed. And again, that probably could have been resolved by the agent if they'd probably talked a little bit more to the complainant and worked out what they want. And that really is a key. Really ask your customers, what outcome are you seeking? Because sometimes you can be chasing up the wrong tree, and what they really want is not what you're trying to resolve. Okay, so another example of a mutual resolution was they provide an itinerary that required connecting flights. So had a very difficult, was a strange country. The flights had been booked there. So she's given that itinerary to the agent and said, oh, can you book me a flight to connect to this flight? Turns up at the airport and the flight had actually been booked for the day earlier. Now, the agent had said, oh, well, this is not our problem. You signed the terms and conditions and you agreed to that. So this one we did have quite extensive discussions with the agent before they did agree to refund. And the reason for this is wild to explain. So yes, they had got the terms and conditions signed, but the whole point was that it was so complex. That's why she'd taken it firstly to a travel agent, and secondly, that it was complex to get a specific fit-for-purpose requirement. I need this to match to so I can, get on this next flight, and couldn't do it. So it was a real duty of care and skill, and also that it was fit for purpose, which are the two consumer guarantees that you cannot contract out of. And we felt very strongly that the agent should be held responsible in this, and they came round and they agreed and said, yeah, okay, we understand, we agree. And they did agree, so she did get that additional flight that she had paid for refunded. Okay, so now what I'm going to go through lastly, and then we'll do a VCAT example. This is one that got appealed to the committee. So the complainant had been told over the phone that the travel was on a minibus. However, when they got there, they found out it was all on public transport. Now, I had decided that there was no breach because it was significantly identified in the website and on the itinerary what the actual mode of transport was. So I found no breach, and the complainant appealed this. And the committee did find that they were satisfied that some fault lay with the agent and that the amount ordered was not sufficient. So in this regard, they relied on that clause that I said does come up quite a lot, which is that all relevant information is disclosed in a plain and easy to understand form. And they did order that the amount refunded was increased to $1,150, which was half of the amount that the complainant was claiming. Okay, and lastly, I'm going to give you an example of one that went to VCAT. So that's the Victorian Civil and Administrative Tribunal. Each of you probably aware, each state has one of these tribunals. Now, this complaint didn't come to us here at ATAS, but I just want to go through it because it shows that this is what you would be dealing with if you didn't use our process. And all complainants have the right to go to a tribunal or court, but by using us, we're much quicker and free to you. So there are definitely benefits in that. So this complaint, itinerary showed return dates of the 30th. However, the e-tickets were for the 16th. And so the agent had booked that because it was the ability to book in advance at time. This was identified on the 8th by the travellers who were overseas at that time. And they started to correspond via an internet like messenger to try to arrange new flights. The agent advised that they were only options to return a week or so earlier or later. There was nothing available at the time that they had originally requested and which showed on their itinerary. Some travellers actually returned on that ticketed date, but the complainant didn't want to cut short their holiday, which is understandable, and so they booked an alternative return flight on a different airline at a total cost of over $4,000. Now, VCAT, the agent had admitted a mistake made by the consultant, but contended that the applicants were not entitled to make alternative arrangements without the approval of the agent, and if they had waited, it would have become possible to book alternative flights with that airline on or about the scheduled date. The decision was that it did breach both of those consumer guarantees, the Section 60 and 61, which is the duty to act with due care and skill and something being fit for purpose. So the question, and this is what I did in the Australian Consumer Law webinar, so if you want to know more about major versus minor failure, I detail it in that. The question was it a major or minor failure? Major failure, the consumer has the right to choose the remedy. If it's a minor failure, then the agent needs to supply in a reasonable time. In this instance, it was decided it was a major failure, and due to the facts of the case, they were entitled to the full refund. Additionally, because it goes to VCAT and the complainant was successful, they also had to pay the fee payable to VCAT back to the complainant. So the most common complaints: cancellation fees, terms and conditions, ticketing errors, misleading, deceptive conduct, the way a complaint was handled. So you end up with another complaint on top of your complaint, and that the complaint policy was not available. So if you can address those issues early, then you can avoid making extra complaints. All right, so sorry to go quickly through at the end. Now my email's not on there. I will tell you what my email is if you don't already have it. It's Naomi, Naomi, @afta.com.au. Happy to take any questions if you like, but I'll go through these other questions that are on here. If booking for an expedition is online and they tick a box accepting the terms and conditions, is this valid or as good as valid as the signed terms and conditions? Well, that is the question. It is, and there is information from the ACCC. They've looked into this, and you know that is the process of booking online today. But in saying that, it's in your best interest to highlight the key terms and conditions as before that. it's only going to result in more problems for yourself, in particularly regarding cancellation and costs for your business. So to avoid your problems for your business, the more that you can make clear the important terms and conditions, it's going to have an overall effect rather than just, okay, yeah, you've legally ticked the terms and conditions, does it apply? So for the most part, it is, but at the same time, we acknowledge and identify that there's problems with this. So if you can incorporate improvements, I would highly recommend it. As I said, the best practice is where we get written confirmation that you have accepted it. And some even online, people that deal online do ask for the email back confirming that you do accept the terms and conditions. So I'd recommend doing what you can so that the consumer is fully aware. It's in their interest and yours. All right. In a group tour scenario, a couple of people make complaints while majority of the group members give a feedback either good or excellent. How do we handle this situation? Look, a really great question, and it really also demonstrates how you have different types of customers and different types of consumers. And what's great though about this is I'm hoping that you're keeping this and recording this, because sometimes having that information is useful to you to say, well, yes, okay, this many people said that. But don't fall into the trap when you do that you're not then addressing this particular complainant and their complaint regarding themselves. Sometimes it could be a minor problem. I usually find that where that occurs, it is a personal thing. They might have been even complaining about their personal relationship with the tour guide or something personal to them. So again, great to keep that data and use that, but don't dismiss that complainant that they're not being heard about it. So I would go through the same process and acknowledge and assess, and if need be, an apology. But it can be very difficult, but definitely highlights it. And look, we've had some of those, and again, it's usually a different demographic. So it might be the rest of the group were quite younger and these people were older. So you do have to assess those vulnerabilities and look at the whole scenario. Somebody else asked about the terms and conditions and e-sign. All right, so I'm over time now, so I'm going to wrap it up. But if anyone has any questions, by all means, please email me at naomi@after.com.au. Happy to assist you at any time, even if you've just got a question about a complaint before it reaches us, always happy to do that. Thank you for your time today. I'm sorry that I tried to get through so much so quickly, but the webinar was recorded. It will be put onto the AFTR website, and by all means, as I said, feel free to contact me anytime. Thank you all for your time. Really appreciate it.